Syrian life. Go ahead.
Good evening to all of you. We have finished up to section 19 of the Transfer of Property Act. I stopped with vested interest. Now we go to section 20, that is where, under what circumstances an unborn person acquires vested interest on transfer. According to section 13, we said that a transfer cannot be made directly in favor of a person who is not in existence on the day of transfer. That is, who is not even avantra, somewhere, that is in the womb of the mother. But there is an exception made. A transfer can be made in favor of an unborn person, but it cannot be made directly. First, it should be made in favor of a person who is living on the date of transfer, and then ultimately it can be made in the name of the unborn person who comes into existence. So, the unborn person acquires a vested interest as soon as he arrives in this world. That is, as soon as he is conceived, and not before that. Before that, the mother of the child becomes the becomes the owner of the property, and as soon as the child is born, that interest automatically gets vested with the unborn child. This is only for academic purpose, please, but it is not much importance. Here, next we go to what is called contingent interest. Contingent interest means it is subject to a condition happening or not happening. On the happening, it gets vested, and on the non-happening, it does not get vested. Contingent interest comes from the word contingency in certain situations. That here, section 21 says where an interest is created on the happening of a specific uncertain event, or the specified event does not happen, it becomes vested when the event happens, and if the event becomes impossible, it gets divested. Here, there are two things. Suppose, let us say, an interest is created in favor of a person by way of a transfer, and to say that the transfer will get operative once the person attains the age of majority, or he, or if it does not happen or it becomes impossible, then in that case the interest fades. First is happening of the event. What is the happening of the event? Suppose you just take another illustration. Suppose A proposes to transfer a property to B in case B marries C, that is his granddaughter through his sister, through his daughter. Then in this case, if that is an uncertain event, because the grandson has not come of marriageable age. Once he comes of marriageable age and gets married to C, then in that case, that uncertain event happens. And as and when the time is fixed and the uncertain event happens, the B gets an absolute interest or a vested interest as far as the property is concerned. If the uncertain event becomes impossible, what do you mean? Even before marriage, B dies. Then in that case, the condition cannot be performed, and that contingency has not yet arrived. Then in that case, the interest fails because the contingent interest that is created is not fulfilled. Here, an explanation is given is where uh, an attachment that is where an attachment of such and then absolute, it is not contingent. That is where an atonement of here here suppose, let us say, the property will vest on the happening of an uncertain event, and as and when the uncertain event happens or is fulfilled, then in that case the interest becomes vested. That is an event, uncertain event, subject to a condition that that event should happen. The time is fixed, and once the time is fixed and the event is completed, then the contingent interest gets converted into a vested interest. But if that uncertain event does not happen, let us say, or let us say B dies before that contingency comes, then in that case the interest fails and the contingent interest is not fulfilled. That is what is section 21. Then we go to section 22. That is, it is said, transfer to a person of extras where who attain a particular age till that age is attained. Here, suppose a contingent interest is created in favor of a class, that is the progenies of the son of the transferor. It says that till they attain the age of 18 years, they will not get the property. Once all of them come to that age of 18 years, then the property will vest with them. Suppose, let us say, of course, God forbid, all of them die. No one is alive till attaining that particular, that is infant mortality or mortality in at an young age. Then in that case, the contingency is not fulfilled, and there is no question of contingent interest being converted into vested interest. That is what 22 says. Then 23 deals about happening of a specified uncertain event. Suppose, let us say, an uncertain event. That is, let us say, uh, uh, here it is said that interest, unless such act happens, here uncertain event happening. Suppose, let us say, what is the uncertain event? Uncertain event is B trying to marry C during the lifetime of A, and if that uncertain event, because B may marry C or he may marry D also in a love affair. The question is, unless B fulfills that condition of marrying C, and that too when during A's lifetime, then the interest, contingent interest, becomes vested interest. But if the uncertain event does not happen, or the B dies even before A, then in that case, the contingent interest or the transfer, a promise to transfer of property does not take place. These are all for academic consumption, please. But since it is section wise, I'm just dealing with that. Then we go to section 24, that is transfer to certain person who survives for some time. That is, here it is said during the property passes to be here. Suppose, let us say, a contingent interest is created in favor of a person who should survive. If he does not survive, the property should go to a third person. That is, A wants to transfer property to B subject to a contingency that B should not die, B should be alive for the interest being operative. But before, and also says, in case B does not survive, the interest shall go to C. Then here, let us say B does not survive during A's lifetime, he expires even before A. Then the subsequent interest that is created in favor of C due to the failure of the prior interest in favor of B, then in that case, C takes the property. That is what 24 deals with. Then we go to what is called section 25. It talks about conditional transfer. That is here, suppose, let us say, here also it's an extension of section 22, 23, and 24. They're almost the same. There they say A professes to transfer property to B on the condition that B should marry during A's lifetime. And in case B does not marry or dies before the interest is fulfilled or completed, then it should go to a third person. Here, the property does not vest with B because he does not survive A, and then the subsequent interest that is created in favor of C takes effect, and the interest which C gets is a vested interest. Then we go to the most important doctrine in all these sections called doctrine of Cypres. Cypres. It is not Cyprus, it is Cypres. S is silent. What do you mean by Cypres? I'll first illustrate it and then come to the section. Here, let us say A promises to transfer a particular property to B on the condition that B should marry with the consent of C, D, and E. Right? A promises to transfer property to B subject to a condition precedent. What do you mean by precedent and subsequent? Sir? Precedent means beginning. Subsequent means later. Condition precedent is also called the doctrine of Cypres. Cypres. That is, A professes to transfer a property to B on the condition that B should marry with the consent of C, D, and E before he gets the property. So, what is the precedent that has to be followed, sir? Precedent is B should marry. Yes, okay. But what he should do? He should take the consent of C, D, and E, right? In this case, let us say E expires, E is no more, and B is not able to take the consent of E to fulfill the condition precedent, but he takes the consent of C and D and gets married. Then, in that case, substantial compliance of a condition precedent is sufficient and total compliance is not required. And this in law is called the doctrine of CPRE, CYPRES. Again, I repeat, it is called the doctrine of CPRE. Again, I repeat the illustration, sir. A professes to transfer a property to B on the condition precedent that B should marry during A's lifetime, and before marriage, he must take the permission of C, D, and E to get married. And suppose, let us say, before he gets married, E expires and E is not available. Then, in that case, if he takes the consent of C and D, it is sufficient compliance, substantial compliance, that he has complied with the condition precedent that has been imposed, and it is more than sufficient as per law is concerned, because E is no more. It is not possible to take the consent of E. The law is not that rigid to say no, 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 E is not alive, so the condition fails. No, he can take the permission of C and D and complete what is called substantial compliance and then go ahead. This is called, in law, called doctrine of CPRE, CYPRES. Then we go to section 27, that is conditional transfer to one person coupled with interest of failure of prior disposition. Suppose, let us say, conditional transfer is made in favor of a person coupled with interest and is a failure of prior disposition. And suppose, let us say, it says that in case the prior disposition in favor of B fails, C shall take the property. Then, in that case, when the prior interest fails, the subsequent disposition takes effect. That means it does not get defeated. Here it is said, when the intention of the parties is that the ulterior disposition shall affect only to the extent of prior disposition, and ulterior disposition shall not take effect until the prior disposition. Here, A professes to transfer a property to B on the condition that B should survive A, and also says in case B does not survive A, the property shall go to C. There is a prior disposition and there is a subsequent disposition. What is the prior disposition? Property should go to B. What is that condition imposed? The condition imposed is B should marry during A's lifetime. But before, and also an ulterior disposition is also imposed, saying that in case B does not survive to take the disposition, or the prior disposition fails for any reason, the subsequent disposition which is made in favor of C shall take effect. In this case, suppose we say that B dies even before A, then the subsequent disposition which is there takes effect. That is as far as C is concerned. But here, suppose, let us say, and in proof died the disposition favor if B earlier the disposition fails, then this is what section 27 deals with. That is, a conditional transfer is made, a prior disposition is made in favor of B, and a subsequent disposition is made in favor of C. In case the prior disposition fails, the subsequent disposition should take effect. That is, in this case, let us say the condition imposed is B should not go to England for a period. B shall go to England for a period of 3 years, within a period of 3 years. And suppose, let us say, B does not go to England within a period of 3 years, the prior disposition fails. Then suppose, let us say, B does not go, the subsequent disposition is made, it shall go to C. Suppose the prior disposition fails, the subsequent disposition is, that is because of the failure of the prior disposition, C will get the transfer. That is what section 27 is. Then we go to section 28, ulterior disposition on happening or non-happening of a specified event. Here, this also an extension of the previous sections. It says where a transfer of interest is created to accrue on the condition superadded that In case of a specified uncertain event happens, the interest shall pass, and if it does not happen, to another person. This all the same extension of the section, sir. Please remember, these sections from 20 to 29 are nothing but repetition of each and every happening. That is uncertain event, happening or non-happening. What is the effect of it? Here it says if the uncertain event happens, the property shall get vested. But if the uncertain event does not happen and an interest is created in favor of another person, C, then the C gets it because of the failure of the prior disposition. Then we go to a very important part of the subject called conditions subsequent. Here, uh, here also the same illustration can be given, sir. Suppose let us say A creates an interest in favor of B on the condition that is before the property vests with the B must attain majority, or on attaining majority he must get married to C. Then in that case, there is a condition of the property is already transferred, but there is a condition subsequent that is imposed, whereby it is said B must survive A and B must also get married to C. Here are two conditions. As far as the effect of condition subsequent is concerned, the option of C prey does not apply. It has to be strictly complied with. Then it is if the question is if it is not complied with, the condition fails and the interest created also fails. So condition precedent doctrine of C prey is there. Substantial compliance can be done. But as far as condition subsequent is concerned, it has to be strictly adhered to and it has to be followed in the letter as well as in the spirit. There is no question of substantial compliance. Then next one is section 30. These are all small sections, sir. That's the reason why I'm going a bit at a faster pace. Then section 30 is condition the transfer shall cease to take effect in case specified uncertain event happens and shall not happen. Suppose it is said that the transfer shall fail, shall cease to have effect in case the specified uncertain event happens or does not happen. Here it is said A transfers a farm to B with the condition that he shall not go to England within 3 years, and he shall go to England within 3 years. And on the date of transfer, if he does not do so, he shall cease. He does not get interest, and the interest ceases. Here, the old man is interested to see that his son goes, and mostly there must be Anglo-Indians, because though they are Indians, their loyalty remains towards UK only. Her Majesty, the Queen of England. Here, so the old man is interested to see that his son goes to England for further studies and gets educated there. But the period of 3 years is fixed where he should go to England. But let us say within the 3 years period, he does. It's an uncertain event, so whether he goes or does not go. But if that uncertain event happens, he goes to England within the 3 years period, he gets the disposition. But if the uncertain event does not happen or becomes impossible of performance due to various reasons, that the person does not go to England, then in that case, the interest ceases. Then we go to section 31. There's 4 sections after this. Important section is there. I'll deal with it in detail. Here, section 31 deals with what is called transfer conditional on performance. Transfer conditional, subject to conditional performance. The person constitutes an election. Sorry. A Hindu whose husband has. Here, transfer conditional on performance of an act specified. Condition broken when the performance becomes impossible. Suppose a condition is imposed saying that a person should walk, that is, a person should walk 100 kilometers for 5 minutes and the property will come to him. Is it possible for any living human being, including an animal, to cross 100 kilometers or reach 100 kilometers in 5 minutes? This is an absurd condition which is imposed. The question is, when it becomes impossible of performance, then in that case, the interest fails. That is what section 31 says. 32 is condition, when condition becomes valid, if the constitutes the condition, the creation of interest. That is, suppose, let us say, when is a condition become valid? A condition becomes valid if the uncertain event happens on the appointed day at the time, within the time fixed, and once on the happening on the day fixed or the time for performance fixed on that day, if it happens, the condition is subject to supposed to be complied, then the interest or the disposition carries effect. Then 33 is 33 is when no time is fixed for performance. Then in that case, if the performance becomes impossible of performance, it cannot be done because of various reasons, because of mortality or because of death, because of insanity or because of any disqualification. Then in that particular case, when the condition cannot be performed, the interest also created becomes or ceases. That is what section 33 says. 34 is when the time is fixed. What happens, sir? When the time is fixed, the performance has to be done within that particular period. If it is not done within that particular period, the condition fails. But if it is performed within that particular day, then in that case, the interest starts. Then we come to the most important section in part 1 of the Transfer of Property Act. It is called the doctrine of election. Please remember, election from the Representation of People's Act and election from the point of Transfer of Property Act is entirely different. A doctrine of election is nothing but it's a fiction of law which is created under certain circumstances. Here, doctrine of election would be good in case the right to property is absolute. Today, you know, after the famous cases of Golaknath's case, Keshavananda Bharati's case, the Indira Gandhi's case, the right to property or the 42nd Amendment or so on and so forth, right to property has been made a qualified right. It is not an absolute right today. And later on, we have what is called the agrarian reforms, the Land Ceiling Act of 1973 and the Urban Land Ceiling Act of 1976, whereby each person cannot hold more than a particular land or a particular vacant plot. But doctrine of election still remains in the statute book in the form of section 35. Here it says, where a owner of a property, let us say father and sons, let us put it this way. A father and sons, a father has got two sons. Then, as far as the right to property is concerned, you know, B and C, who are the sons of A, get equal rights, that is 50%, 50% in the property owned and possessed by the father. Here, what the father does is he gives his entire property to his eldest son, A. And as far as B is concerned, he professes to transfer a property which belongs to B to A and depriving B of his property. Then in that case, but he has the father has another property over which it creates an interest in favor of his second son who is likely to lose his property. Here in this case, B is put to election whether to stand by the instrument or to go against it. Here there's a distinction made between Indian law and English law. Here you cannot, that's why it is also called doctrine of approbate and reprobate. You cannot take under the instrument or you cannot take against the instrument. Here, if B wants to get the benefit regarding another property owned by his father, then in that case, what he should do is he should forego property belonging to him. He cannot take a stand. My father has nothing to do with my property. He cannot sell that property. If he sells that property also, it is not valid. I'm not willing for it. He cannot do it. If he wants to take the benefit, that is, he wants to take another property in lieu of his own property, which is transferred to A, then in that case, he must elect whether to take it under the instrument or against the instrument. Take it under the instrument is he must forego his own property and take the other property by way of disposition, or incur what is called under Indian law incurs forfeiture. Incurs forfeiture means whatever benefit is sought to be conferred regarding another property by the father, this man B loses that right. because of not electing in favor of the instrument. He does not want to part with this property. This is Indian law. Indian law is based on forfeiture. You forego that right. You have no right. But English law, because please remember, English people are mostly commercial. So in English law, the position is he can retain the benefit that is given to him. That is the property C which comes to him, and he did not forego property B. But the another person A who anticipates that he will get the property belonging to B, he has to be compensated with money compensation, the market value of the property which he has lost because this man, the B, has elected against the instrument. And he can retain both the property, the benefit, as well as his own property, but he has to compensate A, the loss of the property which he would have got had B opted under the instrument. This is a famous, this illustration is mostly found in the popular case of Cooper versus Cooper. COOPER versus Cooper. COOPER. Again, I repeat this doctrine of election, sir. Suppose under an instrument, A is the owner of property X. Just take it this way, illustration. B is the owner of property Y. As far as property X is concerned, A has got complete disposing powers. Why? Because A is the owner of that property. And as far as B is concerned, B is the owner of property Y. B has got full rights over property Y. Under a single instrument, what A does is he gives the entire property X to his eldest son A, and he professes to transfer a property P belonging to B. As far as property P is concerned, he has no business to transfer that property. Why? Because it is not within the disposing capacity of A. But in lieu thereof, what he does is he has another property, the entire property is given to B. Are you able to understand, please? A and B are there, and C is also there. Let us put it this way. A has two sons, X and Y. A is the owner of property X, and B is the owner of property Y. And both are two sons. Then what he does is, A, in respect of his own property, gives it to his eldest son, A. Eldest son, A. B or whatever it is. Then as far as B's property Y is concerned, he confers a benefit in favor of his eldest son, transfers that property which belongs to his second son. Here, I think perhaps we may jump to the conclusion, sir. What business this old man has got to transfer his second son's property? Well, under a single instrument, he does so. But what he does is he compensates B by conferring an interest over another property, let us say Z. And B is put to election whether he wants to take it under the instrument or against the instrument. Under the instrument means he can take property C in lieu of giving up his property which belongs to him and allow the father to give it to the eldest son. That is taking it under the instrument. Taking it against the instrument means, what does it mean? He does not want to part with the property belonging, that is B. He does not want to part with property belonging to him, and he takes it against the instrument. But in English law, the position is he can retain both the property, the benefit, as well as his own property. But as far as A is concerned, was expecting a benefit, that eldest son, he has to become, he is called the disappointed donee, and he is entitled to be compensated by B for loss of the property which he would have got by the instrument. But as far as Indian law is concerned, Indian law is very, very rigid. Indian law says a period of 1 year is fixed to make the election. Suppose, let us say, B does not want to part with this property, but wants to get the benefit. Then the the Indian law is very, very clear. If he does not elect either to take it under the instrument or against the instrument, Indian law is based on forfeiture. No doubt he can retain his own property, but as far as the other property is concerned, which he is going to get, that he does not get at all. This is the Indian law. This is the doctrine of election. And it is also called the doctrine of approbate and reprobate. Approbate, APPROPRATE, approbate, and reprobate, REPROBATE, reprobate. You cannot take it and you cannot have the cake and eat it too. If you want to eat the cake, suppose the cake has thorns, you must remove the thorns and take it. You have either to take under the instrument or against the instrument. Indian law is based on forfeiture, and as far as English law is concerned, it is based on compensation. That is what is the doctrine of election. Then we go to section 36. Section 36 talks about apportionment, doctrine of apportionment. That is, apportionment ante entante bhagalu cheyadam. That is, make it into pieces. That is what is called apportion. Ina koddiga, ina koddiga, ina koddiga, ina koddiga. That is what is called apportionment. Here, in the absence of a contract, all rents, annuities, pensions, dividends shall accrue on the day to day between transferor and transferee, but not payable on the days appointed for payment. Not pay before the day of. Suppose, let us say, rent is payable on 5th or 10th of every month, or annuities it's payable at the end of the year, or profits is payable at the end of the year, or let us say pensions is also payable at the end of the year, dividends also is payable at the end of the year. Here the section 36 says, suppose let us say there are 3 or 4 people interested in the income arising out of that, then in that case it will be apportioned, it will be divided, or it will be made into bits only on the appointed day when the date is fixed for payment, not before that. That is what is called apportionment. Then 37 is apportionment of benefits of obligations on severance. Suppose let us say here A sells the property to B, C, and D, and annual rent of rupees 30 and delivery of one sheep. That is, B pays half, C pays 1/4, D pays 1/4. Let us say property is acquired. In this case, what happens is a property is acquired. A sells the property to 3 people jointly, and let us say uh, 3 people purchase it jointly. Then in that case, it is leased out to one E. The rent which is derived from that property is, let us say, 10,000. I'm sorry, let us take a round figure, 33,000 rupees. Here, A has contributed half of the consideration. B has contributed 1/4 of the consideration. C has contributed 1/4 of the consideration. Then, when the apportionment is done, they get it subject to their investments made. That is, B will get half of the rent. That is, he'll get 11,150. Then 6,530 like that. So B gets half, C gets 1/4, D gets 1/4. That is what is called when the contributions towards the purchase of the property is made differently, but it is payable only on the appointed date. That is what section 37 deals with. Then we go to transfer. 38 is transfer by person authorized only under certain circumstances to transfer. Here, a Hindu husband has left collateral heirs that the property held by her is insufficient for maintenance, agrees for purposes either religious or charitable to sell a field, part of such property to B satisfies himself by inquiry that the income of the property is insufficient for the maintenance and sale necessary, and acting in good faith buys the field from A, and as between A and B and the collateral heirs at the other point, a necessity of sale shall be deemed to have existed. Here, suppose a loving husband feels that the maintenance receivable by his wife is insufficient. He has got a farm. He wants to sell the farm, and also says half of the income which is derived from out of the sale of that property shall go to my wife, and half of the income which comes out of the sale shall go for a religious or a charitable purpose. Here, what is the necessity that has occurred for sale of the property to make some provision for extra maintenance to the wife? This is absolutely justified. Every dutiful husband has to do it and will do it. Here, the necessity for sale of the property is to provide half of it to charitable and religious purpose and half of it to the wife for our future maintenance. So this section says that this type of transfer can be made and the sale is absolutely justified. Then that is transfer where third person is entitled to maintenance. Here section 39 says, suppose let us say where a third person is entitled for maintenance of marriage from the profits and such property is transferred may be enforced against the transferee. Here, suppose let us say naturally in some houses the girls do not get married within time. There is most of the I think mostly I've seen in Hindu marriages, that is in Nairu marriages, the girls get married after 35 or 36 because they get well qualified and sometimes well educated. వరులు చూస్తూనే ఉంటారన్నమాట ఈమె ఎంఎస్సి పిహెచ్డి ఉంటుంది బట్ ద క్వశ్చన్ ఇస్ యాజ్ ఫార్ as the husband is concerned he must also be an MSc PhD. It's very difficult to find equal matches. That is why I say కయ్యానికన్నా వియ్యానికన్నా సమానపు వాళ్ళు కావాలంటారు తెలుగు. That's what they say. There's a proverb. But here, sometimes what happens is a girl in the family is not married. Then the father of the girl gets anxious about it, and he says he transfers all his property to his eldest son with the condition imposed that part of the property, the money which is derived from sale of a certain property, shall be kept apart for the marriage expenses of that female child. Also to say for future maintenance of his wife or so on and so forth. Then in that case, suppose a third person purchases the property with full knowledge of the charge created towards the marriage maintenance or marriage portion or for maintenance, and he purchases the property, it says, and it is done only to defeat the claims of the beneficiary. Then in that case the third party also becomes responsible to to get there to follow the charge and give that marriage portion to the girl who is unmarried in that particular house. This is what section 39 says. Then section 40 is obligation and burden of obligation imposing restriction on sale of land. That is, it says when the contract is enforced, he may enforce the contract to the same effect as if as liable. Here, say section 40 is not that important, sir. Burden of imposing restriction on sale of land. Suppose, let us say, a burden is imposed, an obligation is imposed that the land cannot be sold unless a portion is kept apart from the benefit for the benefit of a girl who is not married in the house. Unless that condition is satisfied, a property cannot be sold. This is what all is still section 40. Then we go, please remember, general principles are general principles. Except for few doctrines, the real problem would come when we come to specific transfers. It is a detailed discussion has to be made in that. Here, before we go to other sections, I will deal with one doctrine called nemo dat quod non habet. That is nemo dat NEMO space dat DAT space quad QUOD space non space habet HABET. That is what is called no man can pass a better title than what he himself has. No man can pass a better title than what he himself has. That is, please remember, when we deal with our property, we are very, very careful. But when some other's property comes into your hands due to some reason, we become very, very philanthropic. That's why in Telugu they say, Akto somu alludu danam chesinattu. Or in Urdu they say, Lala ke dukan mein nana ki fatiha. That means when the thing does not belong to you, you are very, very generous. You said, yeah, you want this, think that it is your property, take it. You want this sweet, take that. Take 10 kilos, 10, 20 kilos and all, because it is not yours. It is some other's shop where you try to distribute. This you are not allowed to do it. Even if the person buys it and property buys, he does not get title because his vendor also does not get title. Here in this connection, the preamble of every document is very, very important. That is, all of us are Hindus, sir. I mean, mostly we are dealing with Hindus, let us say. When we perform the Shraddh, or what is called the death anniversary of our parents, or when we do the masikal also, that is monthly ceremonies, or when the funeral rites are also performed, there we try to trace our origin to our ancestors, our father, grandfather, great grandfather, great great grandfather. That is vamsa check. That is, we try to remember them also by their names and the gotra to which we belong. Here, that is the reason, sir. When we draft a document, preamble plays a very important part. And please remember, the preamble gives a real picture of the document. In the Telugu documentation which is done, I'll tell you. First they say that is వ్రాయించుకున్నవారు, వ్రాయించినవారు, విక్రయించినవారు, first we are vendor, then విక్రయం పొందినవారు, that is the vendee, then ఆస్తి స్థిరాస్తి వివరాలు, that means the particulars of the property, then ఆస్తి schedule of the uh, property, then the consideration also is mentioned, so on and so forth. But when you draft it in English, you start with the preamble. Normally, you say, oh, the name of the transferor, name of the transferee, and use the word also, which include all their heirs, assigns, and legal representatives. Why? Because in case, suppose, let us say, before execution of the document, the transferor dies, then in that case, his legal heirs become responsible to draft it or to execute the document. But you will have to say how the person has acquired title to the property. That is what is concisely called the flow of title. That is what is called the preamble of a document. Preamble plays a very important part. Here it says, whereas, please remember, an advocate does not bother about the language. We start, please remember, in Telugu literal translation, ante entanta. That means, whereas, entante, the vendor is the absolute sole and absolute and unencumbered owner of house number so and so in survey number so and so at measuring so and so situated at so and so by virtue of having purchased the same through a register from so and so to a registered sale deed bearing document number so and so dated so and so. That's all. First paragraph. Next paragraph. Whereas the vendor of the vendor was the sole and absolute owner of the schedule mentioned property by having purchased the property through a registered sale deed bearing document number so and so dated so. Then again, sir, whereas the vendor of the vendor of the vendor was the sole and absolute owner of this schedule mentioned property by having purchased the same through a registered sale deed bearing document number so and so dated so and so. Next para, sir. What are the valid essentials of a contract, sir? Valid essentials of a contract is offer, acceptance, capacity, consent, consideration, legality of object. That is what is laid down in Section 6 of the Indian Contract Act. First is, whereas the vendor has offered to sell the schedule mentioned property belonging to him to the vendee for a total sale consideration of rupees so and so. Next para. Whereas the vendee has this day paid the vendor, vendee has this day accepted the offer of the vendor and agreed to purchase this schedule mentioned property for a total sale consideration of rupees so and so. Next para. Whereas the vendee has this day paid the vendor a sum of rupees 10 lakhs towards advance and earnest money and agrees and undertakes to pay the balance of the sale consideration within 6 months from the date of this agreement. Next para will be, whereas the vendor has agreed to the terms and conditions laid down by the vendee and agreed to sell the property to the vendee for a total sale consideration of rupees so and so. Then now this instrument witnesseth as follows: 1, 2, 3, 4, and 5, and 6, and 7. Why I am trying to tell you that is Puttu Gotralu, that is the origin of the property, how the property has come to the vendor, how the vendor has become the owner of the property. He can acquire it by any means: sale, gift, partition, court auction, or by family settlement, or any other means. That document number has to be mentioned, right? And then you give the various conditions, sir. What are the conditions stipulated? And then the vendor signs, and the vendee also signs. Nowadays, they're taking the signatures of the vendee also, and also the witnesses, attesting witnesses are also taken. But please remember one thing is schedule of property has to be compulsorily mentioned, because like you describe yourself as Mr. MBS Sharma, son of so and so, age so and so, occupation so and so, resident of so and so. In the same way, also a property also has got a proper description. All that piece and parcel of plot number 49 in survey number so and so, at measuring so and so square yards, situated so and so, Secunderabad or Hyderabad as the case may be, bounded on the north by so and so, south by so and so, east by so and so, west by so and so, and the party sides. This how a document is prepared. Why I am trying to tell you all these things is పుట్టుగోత్రాలంతా తెలపాలన్నమాట. That's why preamble in a document becomes very, very important. And that too, when you go for a housing loan, or when you go for a loan for business purposes, the advocate for the bank insists on all these things. And the Takatu Patram also, what is called the encumbrance certificate, also is insisted. Why? Because the opinion that has to be given to the bank is whether such security can be taken. And the maxim nemo dat quod non habet. A person cannot transfer a property over which he does not have saleable interest, or he has got present rights over the property. How are you going to establish it? You are going to establish it by stating it in the preamble. So preamble plays a very important part in every document, be it a gift deed, be it a sale deed, so on and so forth. So here, nemo dat quod non habet means no man can pass a better title than what he himself has. And for purchasing a property, you will have to go through the linked documents. You have to go through all the documents to find out how the property has come, whether the property is legally purchased or not, whether it has been registered or not, whether it has been registered on the date on so and so, or whether there is any prior documents prior to this. You have to make all inquiries possible. And also, preferably, you go to the registrar office and take a certified copy and search the registers and find out whether such document exists or does not exist, or whether there has been subsequent transactions relating to the property. Why I'm trying to tell you all these things is the Takatu Patram or the encumbrance certificate which you take is not complete. You must be very well aware. There's a clause there. The sub registrar hereby states that the entries made in this particular instrument is according to the entries kept and maintained by the registrar in the usual course of business, and for any errors or omissions in this document, the registrar is not responsible. That is the reason, sir. You will have to make all inquiries possible. It's something like this, sir, when you acquire a bride, when you go for bride hunting, and when you have to find out the antecedents of the family, you must find out their financial background, social background, or their amiable nature, so on and so forth. In the same, and when you go for races, you bet on the best horses. You don't bet on horses which are going to lose. In the same way, when you are going to acquire property, you must satisfy yourself regarding the marketable title of the person who is selling the property. That is the reason, sir. There is a doctrine in the Sale of Goods Act as well as in the Transfer of Property Act to say caveat emptor, CAVEAT space emptor, EMPTOR. That is buyer beware. So please remember, every person will try to sell a property which has some problems. You must try to analyze those problems. You must try to take the legal documents. You must see all the documents are inspected. Better you go to an advocate and take his legal opinion before you can purchase the property. Why? Because name of that quod non habet says no man can pass a better title than what he himself has. So the significance of this maxim is that is in other words, a third person who has no proprietary or title or possessory rights over the property can sell a property belonging to another person and thereby confer title or possessory rights to the other person concerned. That is why name of that quod non habet plays a very important part. But to this, please remember, as told you, an advocate normally revels mostly to the exceptions rather than the rule. The exception to this particular rule is, first exception is doctrine of election as embodied in section 35 of the Transfer of Property Act. What does it mean? Suppose a benefit is conferred on in respect of one property to another person, and that other person's property, the benefit is conferred on the other person, then the person is put to election whether to take it under the instrument or against the instrument, and the doctrine of election is the first exception to the doctrine of nemo dat quod non habet. Then we have got one more maxim, sir, called doctrine of holding out. What do you mean by doctrine of holding out? Doctrine of holding out means there are a lot of people who masquerade in the public that they are the real owners of the property. Mostly you have land brokers, you'll have real estate agents, and you'll have the realtors who do not disclose the identity of the vendor. And the vendor also does not deal with you directly. You have to deal only through the agents. In Mumbai and other presidency towns, the no, I'm not saying solicitors or brokers. You deal only with the brokers. I mean, with the solicitors. Solicitors will have in their custody all the documents. The practice in Mumbai is, suppose you are interested to purchase a property, you have to contact the solicitor. Your counsel has to address the solicitor to say that my client is interested to purchase his property, which is offered for sale. Is your client prepared to sell it? Then this man says, yes, sir, he's prepared to sell it. Then what is the price expected by your client? This is the price expected by my client. Then I say, no, no, sir, please reduce it to so and so. I'm prepared to purchase it. Then the purchase price is agreed upon. And then your solicitor writes to the other solicitor, sir, please send the copies of the documents for scrutiny. Then in the solicitor's office, you scrutinize the document and take a copy thereof and make all inquiries possible, and then try to come to a proper conclusion. And then after you accept the offer, you say, sir, I'm prepared to purchase it for this particular price. Then the solicitor for the purchaser, for the seller or the purchaser prepares the document. It is cross-checked by both the sides, and then the final document is prepared. This is how the practice is in Mumbai, Kolkata, and Chennai. But here in Hyderabad, you don't have solicitors. Mostly very rare you find solicitors. Here it is done mostly by advocates. But nowadays, please remember, no one is coming to an advocate because an advocate quotes a very heavy fee for documentation. They go to the document writer, and because the document writer has got a connection with the sub-registrar, the entire Gampagutta Mata. So they say document is prepared, it's only cut and paste. They have already the pro forma, only what is filled up is the particulars of the property that is sought to be purchased. Here, one thing is this: whenever you want to purchase a property, try to make all inquiries possible, try to take all the documents possible, try to inspect all the documents possible, satisfy yourself regarding the title of the vendor, and try to find out whether he's got a present right over the property or not, how he has acquired it, and make all discrete inquiries. And if possible, go to the registrar's office and also take a certified copy and also inspect the books whether there have been subsequent transactions relating to the particular property, and also give a publication in the newspaper that your client is intending to purchase the so and so from so and so. Any person having any manner of right, title, or interest over the said property shall intimate the undersigned with the concerned papers within 7 days from the date of receipt of this notice, failing which all objections will be waived. So these are the normal precautions you have to take when you purchase the property. Then you call the doctrine of holding out means, suppose a power of attorney or a realtor holds himself as the authorized agent of the owner, and he says that this property is available for sale. If you go to the countryside, you can find a lot of sheds where they say real estate agents, property for sale and purchase. Please remember, don't be guided by that. Definitely go to them. I'm not saying don't go, but try to get all the documents and satisfy yourself as to the title of the vendor, and make all discreet inquiries, and if possible give a paper publication also calling for objections. Then in that case you will be protected and your money is safe. Be very very careful against pseudo people who masquerade in the public as if they have got a right. What I was trying to deal with is, that is, a person holds out to the public that is the agent of the real owner A. The real owner keeps quiet, and the ostensible owner, the pretended owner, holds out to the public that he has got the authority, express or implied, to act on behalf of the vendor and enter into any transaction or bring about a sale transaction. Then let us say the real owner keeps quiet for 10 to 15 years, and at the 15th year, he wakes up and says, my rights are being trampled, my attorney has duped me. Please remember, such objections will not stand in the court, because if the person who has masqueraded in the public as your agent has entered into a transaction which has to be complied whether you like it or not, then in that case the objections raised by the owner will not stand. That is why it is said it's based on the maxim vigilantibus non dormantibus jura subvenient. Vigilantibus 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 non space dormantibus TORMANTIBUS dormantibus Jura, Jura, space, subvenient, SUBVENIENT. That is, law comes to the rescue of a person who is vigilant about his rights, who takes the earliest available action against the wrongdoer and sets him right. Then, let us say, he disputes his right, then law comes to his rescue. But a person who sleeps like a refined winkle wakes up after 20 years and says that his rights are being trampled or rights are being violated, latches or delay defeats his rights. So a person who masquerades into the public that he has got the power of attorney executed by the owner and he has got full authority to deal with the property. He has got full authority to sell the property. He has got full authority to deal on behalf of the owner. And the owner keeps quiet and does not take the necessary action and alert the prospective purchaser. The doctrine of estoppel applies and he cannot dispute the rights of the agent acting on behalf of the principal, that is the owner himself. That is why it is said delay defeats equity. Suppose a person purchases a property through the power of attorney, duly registered, of course, and makes all inquiries possible to trace out who the real owner is, and then he takes the property in good faith and bona fide and for consideration, and takes all steps which a prudent businessman would take in respect of his own things, then the title of the purchaser is protected. That is why it is said these type of people who masquerade in the public that they have got the express or implied authority to deal with the property of the owner. They are called ostensible owners. And the doctrine of holding out is in case you hold them out as your agent and they deal on your behalf, you cannot dispute their liability. That is what 38, 39, 40, 41, 42. Then we go to the important doctrine called section 43. That is called feeding the grant by estoppel. Feeding the grant, FEEDING space DTHE space grant GRANT space feeding the grant by BY space estoppel ESTOPPEL. What do you mean by this? A professes to transfer a property to B, representing to B that he has got absolute rights over the property. Let us say on the day when the transaction takes place, he had no title, he had no right. But subsequently, he acquires rights over that property either through succession or some other mode. The purchaser who acts in good faith and for consideration is protected, and the subsequently acquired rights of A getting that property automatically gets passed on to B, though the title on that day when the transfer was sought to be made was defective. This is what, and it perfects an otherwise incoherent or imperfect or defective title. It is called feeding the grant by estoppel. And A cannot contend and allege, sir, on the day when I made the transfer, I had no right. It is void because of name or that part on habit. But today I have acquired rights. Today I've got the property by way of a particular instrument. I don't want to execute the document. Please remember, by your conduct, by your representation, or by expressly, you have said you have title, subsequently acquired title. A subsequently acquired title automatically gets passed on to the purchaser. That is called doctrine of feeding the grant by estoppel. That is what section 43 deals with. Then, please remember, as far as specific transfers are concerned, I can tell you even beforehand. But as far as general principles are concerned, my knowledge has become a bit rusty because we studied this, I taught this about 15 years back. Here, section 44. Section 44, transfer by one co-owner. It is said where one or two more co-owners have removed property legally competent in the payout interest transfers his share to such property or any interest thereon. The transferee acquires as to such share or interest and as far as necessary to give effect to the transfer. The transferor's right to joint possession or other common or part enjoyment of the property and to enforce a partition of the same, but subject to the conditions and liabilities affecting at the date of the transfer, the share or interest so transferred. Suppose, let us say, a property belongs to two people, A and B, and in the absence of any contract to the contra, A is entitled to 50%, B is entitled to 50%. Let us say A wants to transfer his share to C. C, who is a subsequent purchaser. To what extent A can execute the document, sir? He can execute it only to the extent of what? 50%. Why? Because 50% is his share. Then C, who is a purchaser in good faith without notice and for consideration, he can step into the shoes of A and ask for his 50% share to be demarcated, localized, and delivered to him. And he can, though he is not a member of the joint purchase, he can acquire rights to the extent of 50%. This is what is called Section 44. With 45, I shall close this. Section 45 deals with saying that suppose a property is purchased by three people jointly, right, for an agreed consideration. Then you do not know how much each has contributed. Suppose, just take an hypothetical case, a property has been purchased for 20, for let us say 30 lakhs. You do not know how much A has contributed, how much B has contributed, how much C has contributed. But the recitals in the document show that the vendor hereby transfers all his right, title, and interest in respect of the schedule mentioned property to A, B, and C. How much contribution each one has made has not been clearly mentioned, but the consideration has been shown as a consolidated amount. In the absence of any contract to the contra, or the contributions have been specifically mentioned in the document, all of them have got equal share. That is one third, one third, one third. Are you able to understand, please? This is what Section 45 says. In the absence of any proportionate contributions being mentioned in the document, it is deemed that all of them have contributed equally and all of them are, each one is entitled for one third, one third, one third share each. This is what Section 45 speaks. I think with this we should stop. And now we pass on to the interaction period. We have completed up to 45 sections, please. We now go to the interaction period. Madam, yes. Please raise your hands before you ask your question.
Already any questions today, or can we complete the class?
Yes.
Sir, hello, good evening.
Yes, Nokia.
Sir, అది stable grant by feeding of stable at చెప్తారా?
Yes, madam. I'll explain to it again. Section 43. It says, suppose A wants to transfer a property to B or makes an agreement. Let us take a concrete hypothetical example. On 15/4/2024, on 15/4/2024, A has no title to the property. He has no document to show that he has acquired title to the property. But B, believing A, enters into an agreement with A, thinking that A has got rights over the property. But now the next day itself, A gets title to the property by some other mode, by sale, gift, or whatever it is. Here, by feeding the grant by estoppel means on the day when the transfer is sought to be made, he had no title, but subsequently he acquires title to the property. Are you able to understand, please? And on the date of transfer, he had no title, but the subsequently acquired title perfects the otherwise defective title of the purchaser, provided the purchaser acts in good faith and for consideration. That means no other documentation is required. Even on that day when he had no title, it is deemed that on that day he had title, and the subsequently acquired title shuts the mouth of the seller by saying, on that day I didn't have title, sir. Today I've got title, I don't want to transfer. He cannot do it. Section 43 says the subsequently acquired title, by whichever mode it may be, perfect and otherwise imperfect transfer which has taken place on the day when he had no title. This is called, and the principle of estoppel applies where it says the mouth of A is shut to say, I don't want to transfer the property. Is it clear to you, madam? Yes?
Yes, sir, but the sale is valid, sir.
No, I'm talking
before
only
getting the title.
regarding the title, it automatically passes on to the purchaser by the subsequent acquisition of title.
Okay, thank you, sir.
Mostly, I think it applies mostly in the case of agreement of sale.
Yes, sir.
Is it clear to you, madam?
Yes, sir, clear, sir. Thank you.
Next. Next, please.
Thank you very much for today. As we conclude the class today. Thank you. See you tomorrow again.